Honorable Mshoriwa, from what the listener is saying, and probably many others who are out there who may fear that reforms such as Clause 11 would introduce abortion on demand. From a legal standpoint, is that interpretation accurate within Zimbabwe's current constitutional and statutory framework?
No, that interpretation is actually not correct. It is wrong. First and foremost, I need to emphasize the provision of Section 48 of our Constitution. But more fundamentally, there have been two court judgments that have come. There was the Wilson case against the Minister of Health, where the High Court is ruled that certain sections of the Termination of Pregnancy Act of 1977 were now ultra vires our current constitution. Then there was another case again, which was between the Minister of Health and the Community Health Working Group. Again, the High Court ruled that the old act that we are relying on was no longer aligning itself to the Constitution when it comes to women with mental incapacity. Now, what then transpires is that when courts tell you that there are gaps in the law, it is the duty of Parliament to make sure that you plug those laws. If you don't plug the law, those loopholes, the courts, through their interpretation, may actually create new laws. Yet the duty is supposed to be with Parliament. But what have we discovered in the recent past? We have discovered that those that are rich, those that have their monies, they either board buses, take their kids to South Africa for termination of pregnancy. But those from the poor background, they do not have that privilege and leverage. So what do? They end up going to backyard terminations, which have resulted in many of our kids suffering from fistula challenges and some of them dying from the process.